Okay, good morning, everyone, and welcome to the first part of our two-part webinar series discussing significant construction and adjudication cases of 2022. These two webinars aim to cover key developments in construction and adjudication practice and how these might affect your construction project disputes in 2023. Our webinar today will focus on our chosen top 5 construction cases of 2022. And we will highlight the main facts and legal points from each and identify specific lessons to be aware of for construction contracts and claims. If you would like to ask a question during the webinar, please do so by using the Ask a Question tab. In order to keep within time, we will answer questions at the end of the presentation rather than as we go along. But if we don't manage to get to your question, or if you are listening to a recording of this webinar, we will be happy to address any queries after the webinar by phone or email separately, and our contact details for that purpose are noted on the next slide. So I am Ian Drummond, a partner specialising in construction, engineering and major projects disputes, and I'm joined by my colleague Chiara Pieri, who is an associate in our team at Shepherd and Wedderburn. Our team regularly advises on construction contract issues and disputes across a range of projects and industries, and we therefore have a great deal of experience in litigation, arbitration, adjudication and mediation, where our arguments for clients have to reflect changing judicial approaches to construction law and contracts. I'll now pass you over to Chiara, who will run through the agenda for our webinar today.
Thanks, Ian. So the first case we'll discuss today is the Martlet Homes Limited against Mullally and Co Limited case. We'll then go on to look at the case of Abbey Healthcare Limited against Simply Construct. Our third case is Thomas Barnes and Sons against Blackburn with Darwin Borough Council. Our fourth case is the case of Advance Joint Venture and others against Iniska Limited. And finally, we will finish by looking at the case of A&A Mechanical Contractors and Company Limited against Petroleum Company of Trinidad and Tobago. It's worth noting that in the time available, we will take you through the cases fairly quickly and we'll focus on the key points which we think are most relevant to you. However, there may be other important points that are coming out of the cases that we do not cover today. So our first case today is the case of Martlet Homes Limited against Mullally and Co Limited. And this was actually the first technology and construction court judgment since the Grenfell fire in 2017 to address loss relating to combustible cladding and is important in the context of building safety. The claimant in this case was Martlet Homes, who was in a housing association which owned 5 tower blocks in Gosport near Portsmouth. And the defendant was Mullally, who was a design and build contractor who had agreed a JCT 1998 contract, the previous owners of the tower blocks to refurbish the towers. Now, the works took place between 2005 and 2008 and included the installation of external wall cladding. Mullally used the Stotherm Classic system, which consisted of combustible expanded polystyrene insulation, or EPS, in the fire barriers. And although the EPS was designed to offer improved waterproofing and gave a sleeker finish, it was composed of flammable materials and therefore it did involve fire risks to the building. Now, although none of these risks materialised in the 5 tower blocks following practical completion, the Grenfell fire in 2017 prompted Martlet Homes to convene a fire safety team to resolve underlying fire risks in the towers, like many others were doing at that time. Now, following an investigation, which revealed both combustion risks and installation defects, Martlet Homes replaced the entire cladding system with a non-combustible alternative, and they also instructed a waking watch until the works and mitigation measures had been completed. Martlet Homes then decided to raise an action against Mullally for the costs of the investigations, replacement works and the waking watch. Now, at trial, Martlet Homes raised 2 arguments. Their primary position was that the fire barriers in the tower blocks had been defectively attached to the walls, amounting to an installation breach, and sought damages limited to the repair costs of fixing the barriers properly to the buildings. Their fallback position was that Mullally's usage of this Stotherm classic system fell foul of the building regulations and was therefore a breach of contract. And this would entitle Martlet Homes to the full cost of replacement. Now, although Mullally accepted a degree of defective installation, they denied that the extent of damage pled by Martlet Homes, and they argued that a simpler and cheaper design solution was warranted. Now, the Board of Agreement as an alternative argument for Martlet Homes, now Mullally submitted certificates from the British Board of Agreement to show that the Stotherm classic system complied with the building regulations at the time of installation. The judge in this case actually decided in favour of Martlet Homes in both of their arguments, but importantly, the court rejected the defence by Mullally that the cladding system fulfilled the safety requirements in 2005. The judge found that the Stotherm classic system did not meet the requirements of building regulations 2000 and would not even have met them had it been correctly installed. And the court also ruled that the certificates submitted by Mullally did not amount to a guarantee or a passport to compliance with the regulations. The court ultimately awarded Martlet Homes £8 million in damages, which included the costs of replacing the cladding and the waking watch. Mullally had argued that their liability for the waking watch was too remote. However, the court held that the fire risk arising from the cladding was sufficiently serious to warrant the watch and that Mullally was liable for it. So, what are the important points from this case? Well, as the first post-Grenfell fire case from the TCC to rule on the issue of combustible cladding, this case sets an important precedent for liability for remedial works to fire defects in high-rise buildings. And although disputes will turn on the specific facts of each case, the court was willing to take a stringent approach to fire safety standards and apply this retrospectively. Just because a cladding system had been approved and certified by the Board of Agreement, or that it had been standard industry practice at that time, that was no defence. And the judge was critical of what he saw as complacency in the construction industry, which allowed safety defects to pass unnoticed. There were two key takeaways from this case, I would say. Firstly, it opens the door for developers and contractors to be liable for the full replacement of cladding systems installed in buildings prior to the Grenfell tragedy. And the courts will be unwilling to accept defences of hindsight or industry practice. There was an obligation to test the safety of materials at the time. However, the courts may be open to restrict liability where appropriate tests have been carried out at the time of construction. The companies which have been involved in the historic installation of combustible cladding should really search and preserve records relating to testing and decision making, as it may be an effective defence against the punitive cost of wholesale replacement of cladding on a building. And secondly, the extent of liability for developers can be very significant. Those defending claims may need to pay for not only the cost of replacing the cladding, but also for ancillary security and mitigation measures, such as the waking watches. And judges are likely to find in favour of claimants who, having identified fire risks in their building, who then go on to take steps to secure safety in the premises pending any remedial work. So arguing remoteness for these costs is probably unlikely to be an effective defence. Where these types of disputes do arise, developers may do well to consider settling damages awards at early stages to avoid the court taking a strict approach, which could ultimately be quite expensive. So I'll pass you on to Ian now, who is going to discuss our second case.
Thanks, Chiara. Our second case today is the Court of Appeal judgment in Abbey Healthcare Mill Hill Limited against Simply Construct UK LLP, which dealt with the question of whether a collateral warranty could be a construction contract such that adjudication applied to disputes under that warranty. This case has now been appealed to the Supreme Court, and we await the final decision. It is a significant case and point that's discussed in the case, so it's definitely one to watch for in 2023. But at this stage, the appellant to the Court of Appeal, Abbey Healthcare, was the tenant and operator of a care home, while the respondent in the appeal, Simply Construct, was the contractor who built the home. Now, the landlord of the home had engaged Simply Construct under a JCT D&B 2011 contract, and practical completion was achieved in 2016. The appellant, Abbey Healthcare, moved in as the tenant in August 2017, but around a year later, Abbey discovered defects, and so Abbey instructed and paid for remedial works. 4 years after completion, in October 2020, Abbey entered into a collateral warranty with Simply Construct, as was required by the landlord's original JCT contract with Simply Construct. And in this collateral warranty, Simply Construct warranted to Abbey Healthcare, who is now the tenant, that it, quotes, has performed and will continue to perform diligently its obligations under the contract. Now, Abbey and the landlord raised adjudication proceedings against Simply Construct to recover damages for the defects, and Abbey was awarded over £900,000 in that adjudication. However, when Abbey went to enforce the award, Simply Construct disputed that the collateral warranty was a construction contract under Section 104 of the Housing Grants Construction Act 1996, and therefore argued that the adjudication decision was invalid because the adjudication provisions of the Act did not apply because it was not a construction contract under the Act. So the question before the TCC was therefore whether a collateral warranty, which was signed 4 years after completion of the construction works, could that be considered a construction contract to which the Act applies, including the adjudication provisions of that Act. Now, the judge at first instance held that since construction had already been completed and no future works were envisaged, the collateral warranty was not a construction contract in terms of the Construction Act, and therefore Abbey had no right to adjudicate. Instead, the collateral warranty was to be interpreted as akin to a manufacturer's product warranty. Abbey then appealed that decision to the Court of Appeal. And in that appeal, the appeal court considered three main issues. Firstly, can a collateral warranty in principle be a construction contract under the Construction Act? Secondly, if it can, did the terms of this particular collateral warranty amount to a construction contract? And thirdly, does the date of execution of the collateral warranty make a difference? Now, on the first point, the appeal court agreed with Abbey that a collateral warranty can, in principle, be a construction contract for the purposes of the Construction Act. The court employed a broad interpretation to, quotes, a contract for the carrying out of construction operations, which is what is defined as a construction contract in the 1996 Construction Act. So the court employed a broad interpretation to that and decided that this definition is not restricted to traditional building contracts. The purpose, as the court saw it, of the Construction Act was to improve a wide range of factors, including the resolution methods available in construction disputes. And it provided that an agreement related to construction operations was sufficient to meet the definition. So the court held in this case that the collateral warranty related to construction operations and was therefore a construction contract. The court also held that, as a matter of generality, an absence of payment obligations under a collateral warranty does not prevent it from being a construction contract, because this would be an overly restrictive approach. Now, on the second point regarding the specifics of this particular warranty, the court found that duties expressed in the warranty concerning the works were capable of applying to both past and future performance. And one of these duties was that Simply Construct, quotes, has performed and will continue to perform diligently its obligations under the contract, close quotes. The court said it was clear that such performance involved and would involve construction works, So in this way, the court found that the primary contract, the underlying building contract, and the collateral warranty were closely linked, and that the former was therefore, the latter was therefore more akin to a construction contract than to a product guarantee. Now, on the third point, the date of signature point, although this particular warranty had been signed after PC, the court decided that its effect was nevertheless retrospective, because the warranties expressed in the document covered guarantees as to the standard of works that were already completed, as well as quality guarantees for future performance. So the court observed that the collateral warranty would, in effect, be pointless unless it had retroactive effect, and that the opposite conclusion would lead to contractors simply delaying signing warranties, collateral warranties, until after completion of works, so as, for example, to frustrate adjudication claims. Now, I think that the following points are important coming out of this case. It is an important reminder to the industry that construction contracts and the obligations and protections that apply to them under the Construction Act can extend beyond the traditional building contract. Now, on the face of it, a collateral warranty, as in this case, signed between a tenant and a contractor 4 years after PC, might seem to be too remote from the original primary contract in order to be construed as a contract for the carrying out of construction operations. But really, this case outcome shows the court will take a broad approach to what is and is not a construction contract, with potentially expensive and unexpected consequences for contractors. So the key takeaway points here are, firstly, a collateral warranty can be deemed a construction contract if it is, quotes, for the carrying out of construction operations, close quotes, provided it covers both past and future performance. And parties should be aware of the potential consequences of these agreements and the possibility of claims under them being pursued at adjudication. Secondly, the case is another general reminder that the courts will seek to give effect to adjudication decisions. Therefore, parties should be very cautious before attempting to defend enforcement of such decisions. And finally, a reminder that this case has been appealed to the Supreme Court, so it'll be very interesting to see the outcome from that court in due course.
Thanks, Ian. So moving on to our third case, which is the case of Thomas Barnes and Sons against Blackburn with Darwin Borough Council. And this case is a High Court decision in which the court considered the validity of termination notices and the complex issue of concurrent delay. So the council entered into a contract with Thomas Barnes to build a bus station in Blackburn. And I've put a picture on the slide here just to show you what the bus station looked like, because it is quite an unusual structure and perhaps lets you understand why there ended up being complications with this project. You can see inside the bus station the weird and wonderful structure that was built. So this project did, unsurprisingly so, experience cost increases and several delays, for which Thomas Barnes had claimed extensions of time. In June 2015, the defendant, being the council, terminated the contract due to an alleged fault by the claimant, Thomas Barnes. And this was before the works had been completed and the council appointed a replacement contractor to finish the project. Following the termination, Thomas Barnes went into administration. And in 2020, the administrators of Thomas Barnes raised an action against the council for wrongful termination, causing loss and expense on the basis that the council's failure to make interim payments and wrongful repudiation of the contract had led to Thomas Barnes going under. The two key issues the court had to consider were whether the council's termination notice had been validly served and what was the allocation of responsibility for the various delays in the project. The parties had entered into a JCT contract, and with regard to termination notices, clause 174 specified that service, quote, shall be delivered by hand or sent by recorded, signed or special delivery post. The council had sent the termination notice to Thomas Barnes first by email only for the notice to arrive by post in the following week, which was 2 business days later. However, Thomas Barnes had been removed from site on the day that they received the email, and the court therefore had to determine whether this termination had been valid, and had it not been, whether the council was liable for repudiatory breach of contract. The court in this case found that the removal of Thomas Barnes from site 2 days before receiving the council's termination notice by post was not a repudiatory breach, and it had no adverse impact on Thomas Barnes. The court found that Thomas Barnes was aware that the termination was imminent, had already stopped all activity on site, and knew that the council was entitled to terminate, and decided that the contract had been validly terminated. The second noteworthy issue was the matter of concurrent delay, and concurrent delay is a complex area of law. I mean, briefly, it's where more than one event of delay occurs at the same time, and there is a mix of responsibility between the contractor and the employer. And in this case, Thomas Barnes alleged that works following the erection of structural steelwork were delayed because of deflection and associated issues which required remedial works, which caused a delay to the critical path, where they alleged that the council was responsible for the steelwork design. However, a separate delay occurred around the same time with Thomas Barnes' roof covering work, and the question was whether the second delay offset the council's steelwork design issues such that no extension of time was due to Thomas Barnes. The court held that Thomas Barnes would be entitled to an extension of time if the council's delaying event had been an effective cause of the delay, even if Thomas Barnes was responsible for another cause of the same delay. But the court decided that the steel deflection and roof coverings issues were concurrent over the period of delay caused by the roof coverings, which meant that Thomas Barnes was entitled to extensions of time. However, given that the court decided that the council had validly terminated the contract, any entitlement that Thomas Barnes may have had to extensions of time had been extinguished by the council's right to remuneration for the replacement contractors that the council had to deploy. So although the courts will be willing to accept the validity of termination notices where the impact on service was incidental or trivial, we usually see that they are quite strict in requirements of proper service for termination notices. So parties should be rigorous in complying with any sort of contractual requirement of serving termination notices, whether that's by recorded delivery or service by hand. And while those who are on the receiving end of the termination notices, they should, I think this case shows again not to readily rely on minor and insequential matters to claim a repudiatory breach, because the courts will take into consideration the specific circumstances of the case and the effect that that has on the parties. Now, secondly, where there are concurrent causes of delay for which responsibility is mixed between the contractor and employer, extensions of time will generally be owed if the employer's delay issue is an effective cause of the delay. The litigants should remember that this assessment is based on the facts and impact on practical completion and rather on delay analysis methodologies, which the court didn't really engage with. So given the complexity of this area, businesses should be cautious before launching high-risk litigations, which could easily backfire. And finally, just to note that in Scotland, responsibility for concurrent delay can be apportioned between the parties. That's the City and Limited against Shepherd Construction Limited case, and that differs from the current position in England and Wales. I'll pass you back to Ian.
Thanks, Chiara. So moving on to our fourth case today, which is the TCC judgment in Advanced Joint Venture and Others against Eniska Limited, which provided insight into the validity of pay less notices and the approach that the courts will take to these. Now, this case involved a dispute between a contractor and subcontractor who had agreed an NEC 3 subcontract. Advance, the claimant, was a JV which had been appointed by United Utilities to design and construct a water treatment works and hydroelectric station in Cumbria. Advance, in turn, had subcontracted to Eniska, the defendant, to perform electrical installation for the project. Now, the NEC 3 amended subcontract contained the following payment terms: ENISCA could make applications for payment before the contractual payment assessment date. Advance had to assess the sum due for payment at each assessment date and issue a payment certificate within 3 weeks of that assessment date. Payment then became due 21 days following the assessment date, and a party looking to pay less than the notified sum had to notify the other party no more than 7 days prior to the final date for payment. So that last point was the pay less notice requirement. The dispute in this case arose over ENISCA's payment applications numbers 24 and 25. The parties provided payment applications and notices through a document upload system known as CMAR, but Advance did not issue or did not upload a payment certificate for ENISCA's application 24 and paid nothing. However, Advance did issue a payment certificate for application 25, but simultaneously attached a pay less notice labelled AFP 25 so as to reduce application 25 from £5.1 million to £2 million. That pay less notice was issued 1 day prior to the relevant expiry date for pay less notices relating to application 24, but within the 21-day period for application 25. Advance stated, however, before the court that the pay less notice related to both applications 24 and 25. Or rather, that was the argument that Advance initially made at adjudication, because the main issue that the adjudication involved was which payment application the pay less notice actually applied to, because ENISCA was suing for payment in that adjudication of its application 24. And the adjudicator found in favour of ENISCA, declaring that Advance did not issue a payment certificate in time and that their pay less notice was against application 25 and not 24. Advance was therefore held liable for the £2.7 million application 24 in whole, and that was on a smash and grab basis. Now, when matters went to court on enforcement of the adjudicator's decision, Advance raised a Part 8 claim, which is effectively a counterclaim in the TCC, to attempt to establish the validity of its pay less notice and in order to avoid having to pay the adjudicator's decision. Now, before the court, the parties' arguments revolved around the payment cycles contained in the Construction Act. Provisions in the Construction Act, in essence, as we all know now, oblige the paying party to pay the sum applied for by the payee in the absence of a valid payment certificate or pay less notice, and that is regardless of whether that sum in the payee's application reflects the true value of the work done or not. ENISCA claimed that payment notices under the Act had to be referable to specific individual payment cycles and could not attach to just any application. The cycle of due dates and final payment dates was a strict regime, it said. In contrast, Advance argued that there was nothing in the Construction Act which prevented a pay less notice from attaching to two different applications, and that instead the Act was concerned only with time limits by which pay less notices must be issued. Advance also said that in this particular case, it would have been clear to the reasonable recipient that the terms of its pay less notice did not intend to make any further payment. The court upheld ENISCA's argument that payment notices must refer to individual payment cycles. The interpretation of PLNs is an objective test, it said, and is concerned with how the reasonable recipient would understand the notice. Therefore, the subjective purpose of the notice is irrelevant, and what mattered was whether the document was in substance, form, and intent a pay less notice applicable to the payment application in question. And the court agreed with ENISCA that the phrase notified sum in the Construction Act meant that pay less notices had to attach to individual payment cycles, and it was not possible under the statutory regime for notices to be referable to more than one payment cycle, in this case to applications 24 and 25 both at the same time. And moreover, in this case, there was no actual reference in the Payless notice to application 24, and so it would have been unreasonable to expect ENISCA to understand the PLN to apply to that application. The document name quotes AFP 25 close quotes in and of itself indicated that the notice concerned application 25, so the court dismissed Advance's counterclaim. So the important points here are firstly that Payless notices and the 1996 Act payment regime more generally are a common source of construction disputes, and this case is a useful back to basics restatement of the principles governing Payless notices. And parties would be well advised to adhere to these in consolidating their payment processes and before choosing to raise court actions on such issues. So to highlight, 1, Payless notices can only be referable to a single payment cycle, and this reference must be clear and readily understandable to a reasonable recipient. And secondly, Payless notices should be drafted clearly, leaving no room for doubt as to their form and intention, and they should be communicated to the other party according to the mode of communication and the timelines set out in the contract, or if not specified, according to the 1996 Act. Payment cycles are a strict regime, and the courts are reluctant to depart from the requirements of the 1996 Act.
Thanks, Ian. So I'll just move on to our fifth and final case, which is the case of A&A Mechanical Contractors and Company Limited against Petroleum Company of Trinidad and Tobago. And this case concerns the status of without prejudice communication, specifically in relation to final account negotiations. So in this case, A&A Mechanical Contractors were the appellant, and they claimed the value of variation work carried out under their construction contract with Petroleum Company of Trinidad and Tobago. And at first instance, A&A relied on a letter written by Petroleum in June 2008 as agreeing the values of certain variations. And this letter was not marked without prejudice, but it was written as part of a process of discussions aimed at reaching an agreed final account value. And at trial, Petroleum objected to the 2008 letter being admitted in evidence on the basis that it was part of without prejudice negotiations between the parties. The judge did not accept this argument and subsequently awarded A&A the amounts Petroleum had agreed in this letter. In December 2019, the Court of Appeal held that the June 2008 letter was a without prejudice communication and was therefore inadmissible, therefore setting aside the previous award. And that decision was then appealed to the Privy Council, which is the current case. And the issues the Privy Council had to consider were, 1, whether the Court of Appeal was correct to find that the June 2008 letter was without prejudice and inadmissible. 2, whether the Court of Appeal was correct to interfere with the judge's approach to certain variations. And thirdly, whether the judge erred in failing to make an award with respect to interest. Now, we're talking about this case because of the importance of the first issue that was considered, and the Privy Council ultimately allowed the appeal and found that the June 2008 letter was admissible in evidence. Now, usually statements made against your own interests, for example, admissions, are admissible in evidence, whereas the purpose of the without prejudice rule is to prevent any written or oral statement made in a genuine attempt to settle an existing dispute from later being put before the court as evidence against the party that made the statement. And where it is used, that communication will be considered privileged and confidential. But the phrase is often misused, especially in the construction context, where parties tend to use it more as an attempted reservation of rights, i.e. that the position or value that they're advancing in that communication is without prejudice to their right to taking a different position in the future. And in this case, the Privy Council agreed with the judge at first instance and concluded that the communication from June 2008 was admissible. It reached its decision on the basis that the agreement made at the meeting in May 2008, which was then recorded in that June 2008 letter, formed part of a process under the contract for arriving at a value for the work. And as the contract intended that this process should be open, then the letter was therefore admissible. So what can we take from this case? Well, I think it's helpful guidance from the highest court as to the application of without prejudice negotiations, especially in the final account context, where the without prejudice tag is not used, then it is likely, although not automatic, that these communications can be relied upon in any subsequent proceedings. But where without prejudice is used, be aware that that does not necessarily afford protection from these communications becoming admissible. What we would recommend is that where you do want this without prejudice rule to apply, to try and use clearer and more expansive language so as to protect your position. For example, this email is written without prejudice and is a genuine attempt to settle. In England, the term subject to contract is often used in addition, and it signals that an agreement is non-binding pending a formal agreement being put in place. However, this term is not really recognised in Scotland, and generally more weight is given to the without prejudice phrase in England and Wales. So that's just something to be aware of.
Thank you, Chiara. So that finishes our presentation and the 5 cases we thought worthy of mention in our webinar today. Just to recap the main points, Chiara's put up the slide which sets out the principal points that we'd like you to take away from our presentation. I won't read those out because I'm aware that we've now gone slightly over time. But these slides will be issued to everyone who has signed up to this webinar, so you'll receive those in an email communication later on. So you know, please do have a look at those at your leisure. Now we do have time for any questions that anyone has.
Yeah, I think there's one here that you could potentially answer, Ian, that comes out of the advance case that you discussed about pay less notices. And the question is, does a contractor's application have to stick to the rigorous requirements that you set out, which are required for pay less notices?
Yeah, and that's an important point, actually. Thanks, Garrett. I mean, it is a very important point because whilst in that case we were concentrating on the requirements for payers and pay less, who are issuing pay less notices, and what the points they have to adhere to in terms of content, in terms of clarity, in terms of timing, and so on. Actually, in reality, the same applies to contractors' applications where a contract requires an application. So in other words, in order for an application to be valid and to justify a so-called smash and grab claim, which is a claim where a sum that's applied for would become automatically due without regard to the merits in the absence of a payment notice or pay less notice by the payer. So in that situation, in order for a contractor's application to found such a claim, the application would also need to be unambiguous in respect to the payment cycle to which it referred. It would need to be issued in the correct format if the contract required a particular format. It would need to be issued in the correct way. So if there was a notification clause that required a particular mode of communication, it would need to follow that in order for that to be a valid application to found such a claim. And the point there is that the court takes a very strict approach regarding requirements of payment notices and pay less notices by payers, but it takes an equally strict approach to the requirements of contractors' applications, because the court says, quite reasonably so it seems to me, that what applies to one side should also apply to the other, particularly when one considers, you know, the substantial liabilities that can arise from smash and grab claims. So that's a rather long way of answering your question, Chiara. The short answer would be yes.
Great, thank you.
Okay, so yeah,
yeah,
I think, sorry, Chiara, I was just going to say, I think we've probably run over time a bit, so we should probably end the webinar there. And thank you all very much for listening and joining us. As I said, the second webinar takes place in 2 weeks' time. And I think many of you will already have signed up for that. But if you have any questions about that, then do let us know. But otherwise, thanks for joining. And any questions that have been addressed to us and that we have have run out of time to answer, we'll respond to separately. So thanks once again, and that is the end of our webinar today.
Thanks, everyone.